Court on Tuesday struck out an appeal filed by the People's Democratic Party and its candidate in the February 23, 2019 presidential election, Atiku Abubakar. Galaxy's Godfrey Eshemoge reports that the appeal marked was filed against a ruling of the Presidential Election Petition Tribunal, which held that Atiku and the PDP do not have a reply to an application filed on May 14, 2019 by the All Progressives Congress. The said application filed by the APC sought, among others, the dismissal of the applicant's petitions challenging the victory of President Muhammadu Buhari at the presidential election. The Supreme Court's ruling, delivered by a 5-man panel led by Justice Dantijo Mohammed, struck out the appeal for having become a statute bird. In their interviews, a cross-section of counsels representing the different parties spoke on the impact of Tuesday's court's decision.
In respect of our request to have access to the data that were used in the conduct of the election. As it were, the Supreme Court appeared in their judgment to have agreed with what the Court of Appeal did, i.e., in saying that we have not given sufficient reasons to have INEC to let us have access into the data that they have at their back end. This data, according to our belief, contains vital information that will assist us to further prosecute our petition.
Like I've always said, without the Supreme Court, politicians would have since destroyed this country. We are grateful to God. Look, the issue is, INEC has never said it has no server, but they quoted a particular server, facts.lie.nigeria.com. And INEC says, I don't have that type of server. They even quoted the number of the server. We say we don't have.
The court will be reluctant to prejudge a matter that is substantive in the case upon an interlocutory proceeding. And that's what they did today. You recall that at the Court of Appeal, the application that cranked up this appeal was that the appellants wanted the server, they wanted to inspect a server which the first respondent INEC said did not exist. You know, and was a major part of the case. So the Court of Appeal said, look, following this long line of cases and the tradition of our jurisprudence, that to grant that order will be like saying beforehand that the server which has been contested to exists.
This decision comes barely 24 hours to the closing of arguments by parties to the petition, scheduled to come up on Wednesday, the same day that the date of the delivery of the final judgment will be made public.